In today's lecture, we're going to cover fraud as well as a few other related offences such as bribery. And in recent years, this has become a lot more easier to cover because it is almost entirely contained in statute law. For the first part of the lecture, we're going to be focusing on the Fraud Act 2006, and we'll move on to the Bribery Act 2010, as well as some other offences that are still contained in the Theft Act 1968. So with all that in mind, let's get started with fraud. Before we get into the actual substance of the Fraud Act 2006, it's worth going over some of the core principles that we're going to be looking at consistently throughout the various sections and familiarise ourselves with these concepts, because you may need to apply them within the context of a problem question, for example. We can start by looking at dishonesty, which obviously comes into fraud quite a bit, and for this we simply apply the Ghosh test from 1982. In other words, was the action dishonest according to the ordinary standards of reasonable and honest people, which is an objective element of the test, and if that does apply, then we go on to ask, did the defendant realise that reasonable and honest people regard his actions as dishonest? And that introduces a subjective element to dishonesty. So whenever we mention dishonesty in relation to the Fraud Act, this Ghosh test is what we're basically applying. Moving on, fraud also talks about the concepts of gain and loss, and this is defined in more detail in section 5 of the Fraud Act 2006. But essentially for our purposes here, it can include money, it can include property, and also personal property as well. And this doesn't necessarily have to be tangible property, it can be intangible, and when we talk about things in action, which I put on the slide there, we're thinking about things like shares in a company. So it has a very broad range, the idea of what can be gained and what can be lost as a result of fraud. Gain also includes keeping what you already have, so it doesn't mean actually sort of gaining property as say, it might mean not giving away something that you should have done. And in a similar fashion, loss includes not getting what you might otherwise get. So you say, oh, well, don't worry about paying for that meal if you've signed a contract or something like that. So you can see how fraud might work in those ways, where you don't necessarily literally gain some tangible or intangible property, but instead you simply don't gain something that you should have done. We'll also talk a bit about intention. So this can be sort of a direct intention, but it also goes a little bit further and can include foresight of a virtually certain consequence. So it's still quite a high test for intention, but there is a little bit of flexibility there, and doesn't just have to be a direct intention for someone to do something. So section 1 of the Fraud Act 2006 basically sets out the key offences, and these are contained in sections 2, 3 and 4. So we'll go through these in turn. So starting with section 2, we have false representation. The actus reus, or the acting part of this crime, is that the defendant makes an untrue or misleading representation. And for the mens rea, or the mental element, we have this concept of the defendant acting dishonestly, so thinking back to the Ghosh test, knew the representation was or was likely to be false. And there also has to be that intention, which we've just mentioned on the previous slide, to make a gain or cause a loss. So this introduces all of the essential elements that we've talked a little bit about earlier. So we can apply those concepts or the elements of fraud to this section 2 offence of a false representation. It's important to say that the representation itself doesn't have to be an express representation, can also be implied as well. And also this is a conduct crime, so it doesn't rely on the victim actually acting upon the false representation. If the defendant himself has made a false representation, that is enough to secure a conviction. Section 3 is fraud by failure to disclose information. Again, we can look at the actus reus and the mens rea. So the actus reus is simply the defendant failing to disclose information that he had a legal obligation to disclose, and the focus there is that there must have been a legal obligation to disclose the information. The mental element, D, defendant intends to make a gain or cause a loss, so relatively simple. And where this legal duty can actually come from is a range of sources. We've got statute as an example, contract, fiduciary duty. can even extend to things like customs within a particular trade as well. And finally, we can say that there can also be liability even where the defendant was unaware of the legal duty. So we're essentially establishing here a strict liability offence whereby the defendant can still be convicted even if he perhaps was not aware of a legal duty to do something. And that falls within that sort of mens rea element about how we're interpreting that intention. Section 4 is fraud by abuse of position, and when we're talking about a position, we're really talking about the position of having a fiduciary duty to someone else. Section 4 of the Act describes it in particular terms, but essentially it amounts to a fiduciary duty, and the defendant in this circumstance is abusing her fiduciary duty to another person. The mental element is that the abuse has to be dishonest and intended to make a gain or cause a loss. So again, returning to those key elements we talked about at the start. So before we finish, we can look at some of the other offences as well. Under the Fraud Act, it's worth mentioning about sections 6 and 7, and this includes a range of things to do with the articles for fraud. In other words, things that can be used to actually perpetrate an offence under the Fraud Act 2006. And it's important to remember the context for this act. This was when computers were increasingly being used for committing fraud. And so when we're talking about possessing, making or supplying articles for fraud, this could also include particular pieces of computer software, for example. So a person could be convicted under section 6 and 7 if they were involved with that piece of software, for example. The other one that I want to mention just before we do move on is section 11, which is obtaining services dishonestly. So you can look at section 11 for a fuller description of that. More recently than the Fraud Act, we had the Bribery Act 2010, and there's two key sections. The first one here. Basically, section 1 is all to do with a person, the defendant, giving someone a bribe, and section 2 is also to do with the defendant receiving a bribe. So both ends of the bribe, the giving and the taking of bribes, are caught within the Bribery Act 2010. Section 1, the giving of the bribe, is basically promising or giving some financial or other advantage. So it doesn't have to be money. It could again come to sort of like property. It could be something completely intangible, like a job offer, in order to persuade another person to act improperly, or they do so after the fact as a reward for them acting improperly. And section 2 is, as we said, receiving, also agreeing to accept a bribe as well. So very finally, we have, going back to the Theft Act 1968, although the Fraud Act 2006 did remove some offences from the Theft Act 1968 and brought it more up to date, there are still important elements of the Theft Act that remain in force and are worth being aware of when answering a problem in this area. So we have false accounting, which is described under section 17. There's also the possibility for corporate liability for fraud offences under section 18, so it doesn't just have to be a natural person who is prosecuted for fraud, it can also be a corporate personality as well. Section 19 covers false statements by company directors, 20 suppression of documents, and finally just a quick word on blackmail, which is an offence under section 21 of the 1968 Act. The actus reus of blackmail uses the rather antiquated language of a demand with menaces, and the mens rea covers a view to gain for himself or another, or with intent to cause loss to another. So it's almost sort of using that similar language to the Fraud Act 2006, but this is in application to blackmail. However, there is a defence to blackmail within section 21, and it can be allowed if the demands have reasonable grounds and the menaces are proportionate. So if a landlord is seen to be blackmailing a tenant, then if the landlord has a legitimate reason for doing so, and the proportionate demands are, say, the tenant moving out of the property, then as long as that's all above board, then it can't be said that that is blackmail. So that covers fraud in some level of detail and also goes over the basics of bribery and hopefully gives you some indicators to some other offences that might also be relevant when studying criminal law. If you do have to cover this area, particularly in an exam, it's important that if you do get to take a statute book in with you, that you do rely on it quite heavily, because it sets out quite clearly what the offences are, including the actus reus and the mens rea, for all of the main offences that you will have to cover. So it's just a question of being aware of where you need to look within your statute book. I hope that you've enjoyed this lecture. If you did, make sure to leave it a like, subscribe for more content in the future, and if you've got any questions, then leave those in the comments box below. Thanks very much again for watching, and I'll catch you soon. Bye!